Are there any alternatives to filing a lawsuit when you get into a labor dispute? Welcome to this segment on labor dispute mediation. Let us answer your questions. Preparation for mediation. To try and advance harmonious relations between laborers and employers, before a lawsuit, in principle, there will be a mediation process. If a party hasn't applied for mediation and files a lawsuit first, according to regulations, the court will first launch mediation proceedings. So, if I receive notification of labor mediation proceedings, do I have to attend? In order to resolve labor disputes between laborers and employers effectively, both parties, their legal representatives, or someone who has the ability to make an agreement should be in attendance. What should I do if I can't attend on the designated date? You can appoint an agent if they hold a signed trustee letter, which states clearly who has entrusted whom, the case number, the cause of action, and the rights accorded. Reminder: if you want to present facts or evidence, do so on the first mediation date. The court will try and complete the mediation within 3 months, with 3 mediation sessions, to protect the rights of both parties. Understanding the mediation notification letter. After you receive a notification letter of the mediation proceedings, the most important thing to note is the case number and the cause of action. That way, the court attendants can check your case and the cause of the dispute. The time of arrival indicates the time the mediation proceedings are scheduled to begin. Note the location of the proceedings, including the mediation room number, to avoid going to the wrong place on that day. The notes column will give details of anything you need to pay attention to during proceedings. Preparing for court. If you're attending court in person, remember your appearance should reflect your respect for the court. Ideally, you should register your attendance at the court early, giving yourself time to find the courtroom. Please make use of public transportation when possible. There are 2 ways to register your arrival at court: at the counter or the check-in kiosk. After you have registered and arrived at the appointed mediation room, wait for the court attendant to call you in. If it's not your turn yet, you can stay outside in the waiting area. If the appointed time arrives and your case hasn't been called yet, the previous case may have gone over on time. Like hospital clinics, courts hear several cases every day, so please be patient. Your rights in the mediation process. After entering the mediation room, please remain silent and be respectful. The Labor Mediation Committee is made up of a judge and 2 professional mediators with knowledge of the field and experience. They are in charge of mediating. They will assist both sides in resolving the dispute in a neutral and fair way. The mediation process can be abbreviated, allowing both parties to give their views and then listing points in dispute. If necessary, evidence can also be explored, allowing both parties to get a clearer idea of the facts and which party is at fault. A mediation has the same effect as a confirmed judgment, so parties must adhere to the contents of the mediation document. If the other party does not fulfill the agreed-upon mediation, you can take a record of the mediation agreement to the court's civil enforcement office to enforce the agreement. Going through a mediation has many advantages. As well as not having to file a lawsuit, you can save time and money and avoid the other trivial affairs that lawsuits entail. If both parties are willing to take part in a mediation, but they can't immediately come to a resolution, they can agree to let the mediation committee decide the conditions. If neither party can agree to the mediation results, the mediation committee can decide on a suitable resolution. If this is not disputed within 10 days, it will be seen as confirmed. Maybe you're curious if what you've said in an unsuccessful mediation can be used in litigation. Don't worry. Without a written agreement, no proposals or compromises made in the process of an unsuccessful mediation can be used as the basis for a judgment in litigation. The judge will consider the dispute itself, so you can feel free to say what you want to during a mediation. You shouldn't panic when you get into a labor dispute. Let's protect our rights together.